Hey folks, this is an ERISA legal update. This part concerns legislation. Now, this is originally a presentation I gave to the Medicine Benefits Council, but I have slightly revised it and updated it so I can put it online because I think it might be of more general use to a lot of people. So let's just start with the main takeaways. I always like to put it up front so that if you click away, if you stop listening, at least you learn something. So this one is on legislation, as I said. The main takeaways are the Secure Act, which was part of the larger budget deal, and then I want to flag the CCPA. So the Secure Act, the important thing to remember is the new participation threshold of 500 hours and how that's going to affect uh, defined compensation retirement plans, qualified plans, especially say 401k plans, the lifetime income notice rules for DC plans like 401k, and the required minimum distributions at age 72, which is an increase from 70.5. Also talk about the budget deal, the Cadillac tax was repealed, there's some disaster relief, and the change to in-service distribution rules for folks age 59 and a half. And then I'll talk about the California Consumer Privacy Act. The other videos concern litigation and regulation, and here are some of those topics. If you are interested, go ahead and check those out as well. None of these videos are going to get too in-depth. The idea is to just flag important issues, and then if you need to do more research based on your specialty or based on your legal needs or your general any other needs, then you can go ahead and dig deeper. So I'm just trying to do a quick survey so that you know all this stuff is out there. So moving again to the legislation, we're going to do Secure Act, the tax changes, and CCPA. The Secure Act is going to take up most of the presentation. It's technically the Setting Every Community Up for Retirement Enhancement Act of 2019. It was effective and signed as of December 20th, 2019. So the top line provisions that DC plans really need to know is going to be that 500-hour rule, the lifetime income notice rules for DC plans, the required minimum age, the RBD or RMD or MRD, whatever acronym you prefer to use, is going from 70 and a half to 72. And then there are also going to be some changes to the post-death required minimum distribution window, and a lot of people are going to have to move into a 10-year window. So if you've got some people in that situation, you're going to have to change rules as well. Some other major provisions are the pooled plans or open MEPs. Some of the safe harbor 401k rules have been loosened. There is a safe harbor for the lifetime income provider to a DC plan, which parallels with the lifetime income notice. There are some withdrawals for new child expenses will be allowed, some retroactive plan adoption rules. They're talking about a consolidated 5,500. And then there's some other additional provisions, and we'll flag those as well. Tax return penalties, 5,500 penalties. There's some small employer credits. There are very narrow provisions for DB plan relief if you've got a pension plan in narrow circumstances. Rules against plan loans by a credit card. Some niche income types are going to get a little bit of generous rules. There's some guidance on 403B plans, and then there's also a change to the IRA rules, no max age. So all of this you can amend for Secure Act amendments by the end of plan year 2022, and longer if you're a government plan. So I like to look at an act like this, especially with a lot of unrelated provisions, and sort of recategorize it myself. I find it a useful exercise. This is my informal categorization. If you don't find it useful, then I apologize, but it helps me to look at what we're really seeing. And I see it as 5 or 6 groups, roughly. So tax credits and relief for sympathetic employers we like. Tax credits and relief for sympathetic individuals, people we like. Some DC plan simplifications, some administrative simplifications, some revenue raisers, and just generic participant protection, which doesn't really fit into the other grouping. So you can sort of see what I mean as we go through. So for employers we like, they get tax credits and relief. The pooled plan probably fits in that category. It's generally for, I thought that smaller employers could really benefit from open MEPs or pooled plans. And you get the new code section 413E, which is 101 of the Secure Act. And you'll notice on here I've got In brackets, I sometimes point out the section of the Secure Act where you can find these provisions. So if you want to dig in more yourself, that's what I'm looking at. So the pooled plan provisions allow unrelated employers to use a single pooled plan. You don't need commonality. You don't need a nexus of interest. You don't need the stuff that you might have needed in the past. The idea is that you can reduce your costs. You can share a plan document, a 5500, the independent plan audit. Each employer in a pooled plan is going to be treated as the plan sponsor, but only with respect to that employer's employees and beneficiaries. So you're not the plan sponsor of all the others. The important innovation here is the elimination of the one bad apple rule, which would have disqualified a pooled plan if one of the many different employers involved was disqualified. So that's really an important change. So you're not getting sunk with the bad acts of just one other employer, which would make it difficult to fall into a pooled plan if you couldn't trust what all the other employers were doing. The provider of a pooled plan does the administration, has to make sure that the employers are complying with both the legal rules and the plan rules. The provider has to be the fiduciary, the named fiduciary has to be the plan administrator, and has to acknowledge those in writing. The provider has to register with the IRS to be a pooled plan provider, and the provider is going to be responsible for the fidelity bond. There are also some provisions in the Secure Act for audits and examinations, which is pretty typical. And this is effective for plan years beginning after 2020. So IRS and DOL guidance is expected sometime in 2020. Some other small employers that we think Congress likes, they gave them preferences in the Secure Act. There's some small employer credits for plan startups and automatic enrollment. So if that applies to you or to your clients or to your or to anybody that you would know that applies to you. For 403B plans, this would be for nonprofit plans. Uh, there was this issue of 403B7 accounts, which are important for a 403B plan termination. The IRS came to a conclusion that a lot of people didn't like. The Secure Act is Congress countermanding the IRS and saying the IRS has to give tax deferral to these 403B7 accounts, which would be relevant in a 403B plan termination. So the Secure Act just forces the IRS to go back and write the guidance saying that these accounts are tax deferred when previously the IRS had come to the opposite conclusion. And what's interesting is the Secure Act makes that retroactive for tax years after 2008. So that's pretty interesting. The Secure Act stepping in and telling the IRS it's wrong. And very similar for church plan rules for 403B for NICOs, these non-qualified church-controlled organizations. For years, they had been covered under a 403B plan, and the IRS kicked them out, said, no, that's not appropriate. And this is just the Secure Act again, Congress countermanding the IRS, saying, nope, show your work, do the reverse, about face. So if those apply to you because you're a small employer or you've got a terminating 403B or a church 403B, then you would know that. But for most of us, those might not be too relevant. We've also got for DB relief some sympathetic employers laboring under some expensive pension costs, is I think the idea. If you're a community newspaper with a frozen pension plan, then I suspect the Secure Act already applies to you because this is written so narrowly that very few plans probably are getting affected. And I really hope they all know that it's meant for them. And I was tight for space, but I just had to include all of the restrictions on how to define what is a community newspaper. I find it very, very interesting. It's a metro area of 100,000 plus. You can have paper or electronic publication. So you could have like an online newspaper, and that would count as a community newspaper. It can't be publicly traded. It can't be controlled by a publicly traded company. It also can't, your community newspaper can't control any other newspaper. Sort of an interesting question. If the website serves a different metro area or the same metro area, but it has a different name, is that the same newspaper? I don't know. Hopefully these community newspapers know quite what that means, but it seems very narrow to me. And then it gets narrower. It must be controlled by a local state resident or controlled by the same family for 30 plus years, or by a trust, and that trust has to be either locals or members of the same owner family, or it could just be a nonprofit, a 501c3 tax-exempt organization. So very, very narrow rules, and then it has to have already been frozen by December 31st, 2017. And this is just minimum funding standard relief. So if you are a community newspaper with a frozen DB plan that has been frozen since by December 31st, 2017, hopefully you know that this applies to you. And if you don't, that's just unfortunate. There's a little bit more general application for non-discrimination flexibility for other frozen plans. You don't have to be quite so narrow a group as community newspapers, but it is generally thought that this would help plans, especially if they're closed or soft freeze, that they could get a little bit of relief on non-discrimination coverage and other tests. And then there's some PBGC relief for cooperative and small employer charity pension plans. So again, I think if that applies to you, you would probably already know it because that is a narrow community, I assume. So now we've got tax credits and relief for sympathetic individuals, for people that we like. The Secure Act gives these individuals a little bit of flexibility on contributions. So if you've got traditional IRAs, you can now make them at any age. Really what this is they just lifted the age cap. Previously it was 70 and a half. Now it is any age cap, so you can continue making your contributions to a traditional IRA. And of course, Roth IRAs did not have a contribution because they are not tax advantaged upon contribution. They are tax advantaged upon distribution or withdrawal. So Roth never had an age cap, but now traditional IRA also has no age cap. And this is effective starting just a couple weeks after the Secure Act. So it's effective now as of tax years after December 31st, 2019. We've also got these special income types for fellowship and stipends and for difficulty of care payments, and how both of these you are often tax exempt or excluded, but you can include them as compensation for IRA purposes. And then with difficulty of care payments, the Secure Act allows a defined contribution plan to consider difficulty of care payments in the 415C limit. And then it also includes a savings clause that you won't fail qualification if the contributions are due to this change by the Secure Act. So relatively narrow slices, but those are sort of people that Congress thought were sympathetic. If we go to a couple other groups, kids, seniors, firefighters, first responders, it's just a lot of little tiny slices for small groups of people that Congress thought were sympathetic. So distributions for a new child up to $5,000 from a plan, a qualified plan, and that can be for birth or adoption, and that's effective now for distributions after the end of 2019. And of course, as I've mentioned several times, the required minimum distribution age has increased from 70 and a half to 72, and that is effective for those who turned 70 and a half after the end of 2019. And there are a couple weird twists on this rule. It's not just so if this applies to you and you're counsel to a plan or you're administering a plan, not all of the 70 and a half rules are changing. Some of the rules are 72, like the required beginning date, but some of the other rules, the more technical rules, might still be 70 and a half. So you need to dig into this. It's not just as simple as everything is 70 and a half. And I find it interesting that this rule, this 70 and a half rule, is from the 60s. It was never adjusted. So as I pointed out in the slides, life expectancy around the time the rule was put in was age 70. So the RMD age was older than people were expected to live. Today, the life expectancy is more like 79. So significantly, the RMD age is significantly younger than life expectancy. Of course, you won't get Congress pushing it back because they have to pay for every year that they're pushing it back. And in fact, the Joint Committee on Taxation estimates that just this change will cost 8.9 billion over 10 years. So if they were to push it out to say age 80 or more, that could cost the Treasury significantly. So that's really why we won't see that. And then we've got a couple narrow slice issues that just apply to small groups of people. This one is very narrow. The volunteer firefighters and emergency medical responders get an exclusion for state tax benefits and reimbursements. Now, this group is a little bit larger than community newspapers, maybe a little less organized. You're less likely to belong to an association of uh, you know, volunteer firefighters than I imagine community newspapers belong to some sort of guild or association for community newspapers. But regardless, uh, hopefully you know that this applies to you if it's helping you. There's also an expansion of 529s. It's for either apprenticeships or student loan repayment, which could be interesting. I'm not sure if that's going to be very significant or less significant than we thought, but certainly it's any expansion in that area is welcome, especially for student loan repayment. Um, and then there are some limits. So if you're thinking about either apprenticeships or you have a 529 and there are no kids left that you would want to pay for schooling, then student loan repayment might be a great idea on that score. And then there was a special provision from the tax reform, the 2017 tax reform, that taxed the unearned income of children. That was a little more expensive than I think they had predicted, so they rolled that back. There are also some simplifications for defined contribution plans, so safe harbor plans. They increase the QACA cap from 10 to 15, so 1% point every year. Now you can go up to 15 instead of 10. And that's effective now for years after 2019. And if you want to become a safe harbor plan, uh, they eliminate the safe harbor notice for the non-elective, but also you can amend to become it much later in the year than previously allowed. So if you want to have a safe harbor plan with a 3% rate, you have to amend anytime before the 30th day before the end of the year. So that's what, December 1st. And at a 4% rate, you can amend at any time before the last day of the plan year. So relatively generous. Sounds like they're making it easier for you to be a 401k safe harbor plan, which I think is something that they would appreciate. There are some lifetime income rules, which I think are getting, at least within the field, are getting some attention, but I haven't met anyone who really thinks that they're going to be very important. I'm not sure why Congress was so big on these. If they were just lobbied heavily, I'm not sure. Maybe I'm jaded, but I'm a little skeptical that these are going to matter that much. But you are going to be required if you are a DC plan, so like a 401k, a 403b, and your ERISA, you're going to have to put in these uh, estimates, these disclosures of the value of a joint and a single lifetime income option, so an annuity, on the annual benefit statement. Now, we don't know what that looks like. We don't know how to do those assumptions. So the DOL, the Department of Labor, is going to develop the model disclosure. And this rule is not effective until 12 months after that rule goes final. So we've got some time, but that's something that if you are, whether you're running a plan or you're advising plans or you are administering plans, this is something that you're going to have to be aware of, that this is out there. And even if you don't offer lifetime income options, you have to tell participants that this exists. Now, if you do want to offer lifetime income options, even though you're a DC plan, which of course traditionally we see DB plans have a normal form of benefit that is an annuity, and DC plans we associate with just a lump sum. But there's no particular reason. I mean, you can see the opposite. Obviously, we know that there are lump sum benefits out of the DB, and obviously you can have a lifetime income option in a DC plan. If you want to add one of those lifetime income options, there is a fiduciary safe harbor, and you can dig into that if you think that might apply to you. It's more or less what you would expect. It's an objective, thorough analytical search that considers ensure financial capability, and then obviously you're going to do the typical thing where you need to look at the costs and compare it with the benefits and the services and the features and everything. Pretty typical. I think that's something that you should already be doing. So I'm not actually sure how much this safe harbor helps. It doesn't hurt, I don't think, but I think this is actually generally what the fiduciary rule or the fiduciary standard would be in this case. But they're laying it out, so maybe that helps a little bit, and that's already effective. That's effective as of the date the Secure Act passed. So if you're looking to do it, that's where you should be focused. Just go ahead and dig into Section 204 of the Secure Act and see what that looks like for you. Um, and then there are these portability rules so that you can direct transfer your lifetime income options to other plans or to IRAs. I'm not exactly sure what that's going to look like, but that's something that we'll all have to be paying attention to. then there are some generic provisions that I label participant protection because I wasn't sure how else to refer to them. But if you've got employees who are working 500 plus hours in 3 consecutive years, they are eligible. They have to be age 21 plus, and this is in Code Section 401k 2D. And that is an interesting development. Obviously, we're normally thinking of the 1,000-hour rule. This is not getting rid of the 1,000-hour rule. The 500-hour rule is different, right? No employer contributions are required. You don't need NIC, you don't need match. And then there's relief from non-discrimination and top heavy, to the extent top heavy even matters. So you don't need to do a whole lot for these employees other than let them in and let them defer into it. So I'm not actually sure that this helps a lot of people. Uh, I think that it might make things a little more complex for plans, but it will not screw up your non-discrimination as long as you're paying attention, as long as you're making sure that you are correctly categorizing these people as 500 plus and not 1,000 plus. Then you can present them to your non-discrimination testing to make sure that you're not counting them against yourself. And that's effective after 2020 for plan years after the end of 2020. And then we've got this rule that I I could not find anything on it for a while. And then when I presented this to the council, I did get some comments from someone who's very knowledgeable, and his reaction to this rule, which is that no plan loans can be made through credit cards, and that's effective as of the Secure Act uh, effective date, December 20, 2019. Uh, he believed that it had to do with taxes. So it might actually be more of a revenue raiser than a participant protection issue. But regardless, don't do that. Don't do plan loans through credit cards. And then we've got some administrative simplification. So a plan has to be adopted by the filing due date for the taxable year of adoption. So that lets you do retro. And that's pretty useful. So you can adopt your qualified plan after the close of the tax year. And that's effective now as of tax years beginning after 2019, the end of 2019. And then we've got this apparently consolidated Form 5500 coming down the road. It just says that the IRS are going to work on it. It doesn't actually authorize it. It starts the process, but it's relatively narrow, right? You've got to have the same trustee, the same fiduciary, the same administrator, the same plan year, same investment or investment options. That's a very similar plan. So I'm not sure how many people this helps. It is interesting. Maybe we'll see more in the rules from the IRS and the DOL that will explain how narrow or broad this will be. But it's I'm not sure that this will help too much if you've got a lot of different plans. If they've got any of those things different, then you're not getting any benefit. So we'll see on that one, but that could be interesting. And then, as I said before, if you want to amend your plan for any of these, or you need to, then you have through the end of plan year 2022, and it's 2024 if you're governmental. And the IRS has the power to extend that out, so we'll see if they do that. And of course, if for some reason if you're in one of those 401(3) or 403(b)s that's terminating, termination obviously cuts this short. But otherwise, if your plan is going to be around through the end of 2022 plan year, then that's how long you have to catch up to these. And there's anti-cutback relief for that. And then we've got some revenue raisers in the Secure Act, like for most people, they're accelerating, or for many people, they're accelerating the post-death RMD window. It has to be within 10 years, so that accelerates some taxes. They're increasing some penalties for failure to file 1040s and 1120s and 5500s and all sorts of other statements. And they're doing some information sharing with Border Patrol and Homeland Security for excise taxes to pay for this. Now, I could talk a lot about these ACA tax changes, but I don't think that most of us really need to. If this applies to you, then you probably know more than I do. All I needed to know was that for sure the Cadillac tax is now repealed and dead. It, of course, was never technically in effect, but they did save that W-2 reporting. So Code DD on your W-2s, that's still going strong. They left that in there. I'm not sure what the plan is, but originally the understanding was that would be used, or at least the starting point to calculate your Cadillac tax. But They have kept it even though the Cadillac tax is dead. They've also repealed the health insurance tax, or the HIT, and the medical device tax. For some very interesting political machinations went into all of this, and meant that Democrats and Republicans, for the most part, didn't like any of these taxes. They just could agree. So even though Democrats and Republicans can't agree on much right now, they all agreed for various reasons that they just did not like these particular taxes. So some of them were enforced for a little while. Cadillac tax never was, but they are all gone. Um, so that and note that there are different dates for when they're gone. The Cadillac tax never came into place. Medical device is for sales after the end of 2019, but the health insurance tax is for years after the end of 2020. Then there's this weird. It's not the Secure Act, although it's often presented as part of it when you read about the Secure Act. This Miners Act. It's meant to shore up the UMWA pension plan, which is its own complex situation, and they pay for it by allowing uh, in-service distributions to 59.5, and that's for pension plans and governmental 457B. So that's supposed to theoretically pay for the potential that they'd have to shore up the UMWA pension plan, the miners' pension plan. So if that applies to you, if you need to allow that, then there you go. There are some other tax changes, particularly with regard to disaster relief, just an extensive amount of information. And if this is something that your plan needs to allow, or that you want to allow, then there's just a lot to cover there. So I'm not going to go too much into the details, but there are all sorts of disaster relief prevention or uh, disaster relief provisions. And so that is something that you should look into if that's going to apply to you. And then we've got some others. These are not directly plan issues. They're sort of vaguely benefits related, but they're not going to fall squarely on plans. And there are many others that I didn't even try to include. So one last thing is I want to talk about the California Consumer Privacy Act. This might not apply to you, and you uh, might have some duties under it without knowing. So I just want to flag it that CCPA did start applying as of January 1st, 2020, and it's for-profit businesses above a certain size, and it's for data for California resident consumers who are natural persons. And broadly speaking, it's got four main rights, which you might recognize from the European GDPR. Right? Disclosures, deletion, decline, and discrimination. So you have to tell people, you have to disclose the type of data you're collecting. You have to delete data upon request, and there are a bunch of exceptions. You have to allow consumers to decline or opt out, and for minors, that's opt in. And then there's a right against discrimination, which is really just anti-retaliation if someone uses their CCPA rights. Uh, we're actually looking at the potential that CCPA could get stronger with something that last I heard, they're calling the CPEA, and so we'll see. But that could have a new state agency and increased fines and more rights and more disclosures. So we'll see where that's headed. And there are a lot of other states that are looking at potential CCPA copycats. As far as I know, none of them have gotten close to pulling the trigger yet, but there have been a lot of serious discussions in many other states. So I think the takeaway here is expect privacy practices to be a major focus in the near future, and that applies if you are a plan, if you're an employer, if you're a plan vendor, if you're a plan advisor. This is going to be increasingly important. So I wanted to flag it because it's going to start affecting everybody. That said, there is a brief exception for employment data, but we expect that to go away. Right as of right now, it's scheduled to go away. So uh, pay attention to that space. See what's going to happen with privacy. That's getting to be a bigger and bigger issue. All right, so that was on legislation. I just want to go back into my takeaways, right? So talked about the Secure Act, the 500-hour rule, going to get those lifetime income notices on your DC plan benefit statement, and the RMD age is up to 72 now. And then a couple other rules. Remember, the Cadillac tax is gone. In-service distributions 59.5, and pay attention if disaster relief is something your plan is worrying about. And please do consider what effect privacy is going to have on your plan in the future. So again, I've got two other videos for this ERISA legal update on litigation and regulation. Check those out if those might apply to you. But otherwise, thank you so much, folks. I appreciate you taking the time.